Any witnesses in support today?
No, the bill has, well, none that are here present.
And I don't believe you have any opposition listed at all. So any opposition to speak today? All right. I think you will be in good hands. We are operating as a subcommittee right now, so we are not able to take a motion, but we will take one on that bill as soon as we're able to. Assemblymember Mendoza. And I know you have a second bill here today.
Yes.
Item 5, Assembly Bill 170, dealing with court reporters and certified transcripts.
Yes. Thank you, Madam Chair. AB 170 clarifies how instant visual display transcripts produced during the trial can be used. Also known as real-time reporting, instant visual display is produced on laptops during a trial. Real-time is actually a very good rough draft of testimony as it occurs, but it is not the certified record. AB 170 defines how these rough drafts can be used to preserve the accuracy of the certified record. The bill is co-sponsored by the California Court Reporters Association and the Deposition Reporters Association and supported by the Judicial Council. There is no opposition to AB 170, as again, it's the same as the one we did last year.
Thank you very much. Witnesses in support.
Madam Chair, members of the committee, I'm Carolyn Dasher. I'm the president-elect for the California Court Reporters Association, and I'm also an official court reporter in Los Angeles Superior Court. Court reporters' advanced technology has grown, so our real-time translation is near perfect. But before a transcript can be certified, it must be proofread, and the untranslates and the incorrect translations must be fixed. And I respectfully ask for your support. Thank you.
Thank you very much. Ms. Herskowitz?
Dr. Herskowitz, on behalf of the Judicial Council, in support.
Thank you very much. I don't believe there's any opposition to this measure either. Don't see anyone coming forward. Okay, very good. Would you like to close Assemblymember Mendoza? Any questions, members? Assemblymember Mendoza?
Madam Chair, just respectfully asking for your aye vote.
Thank you very much. And we do have a quorum, so let's please call the roll for the quorum.
Corbett?
Here.
Corbett here. Harmon?
Here.
Harmon here. Flores? Flores here. Leno? Walters?
All right, we have a quorum. Would someone like to make a motion on Assemblymember Mendoza's bill on AB 170, moved by Senator Harmon? Please call the roll.
The motion is due pass to the Senate floor. Corbett?
Aye.
Corbett, aye. Harmon?
Aye.
Harmon, aye. Flores? Flores, aye. Leno? Walters?
Very good. 3-0. That has enough votes to pass. It will remain on call. And why don't we go ahead and ask for a motion on item number 2, AB 63? Assemblymember Flores, would you like to, Senator Flores, would you like to please move AB 63? All right, moved by Senator Flores. AB 63.
The motion is due pass to the Senate floor. Corbett?
Aye.
Corbett, aye. Harmon?
No.
Harmon, no. Flores? Flores, aye. Leno? Walters?
Okay, 2 ayes, 1 no. It will need 1 more vote, and it will remain on call.
Thank you, Madam Chair.
Assemblymember Mendoza. All right. All right, we have a consent calendar this afternoon. Consent calendar consists of several items. Let me just read them for the record. On the consent calendar today is item number 1, AB number 5 by Assemblymember Evans, dealing with electronic discovery. Item number 6, AB 176 by Assemblymember Silva, which is the annual maintenance of the codes measure. Item number 12, AB 712 by Assemblymember Evans, making it clear that equitable relief can be asked for in small claims court when statutes call for it. Item number 13, AB 927 by Assemblymember Calderon, dealing with construction defects. This is extending a sunset on the Common Interest Development construction defect legislation. Item 15, AB 1046 by Assemblymember Anderson, dealing with the enforcement of judgments with regard to homesteads. Item 16, AB 1059 by Assemblymember Silva, a bankruptcy measure. Item 18, AB 1163 by Assemblymember Tran, dealing with the attorney-client's privilege in decedents' estates. And item 19, AB 1164, also by Assemblymember Tran, another one of our maintenance of codes measures. Without objection, that's the consent calendar. Any objection to that remaining? All right, moved by Senator Harmon. Please call the roll on the consent calendar.
Corbett?
Aye.
Corbett, aye. Harmon?
Aye.
Harmon, aye. Flores? Flores, aye. Leno? Walters?
All right, the consent calendar has sufficient votes to pass. We will keep it on call. All right. Our next author is Assemblymember Fure, Chair of the Assembly Judiciary Committee. Happy to see you here. Welcome.
Thank you very much.
And Assemblymember Fure is here to present AB 83, which deals with personal liability and why am I blanking on?
And also AB 940, which is another issue.
Yeah, let's start with AB 83. Is that okay?
By all means.
Good Samaritan.
Yes.
I knew it would come to me eventually.
Thank you.
Oh, and Senator Benoit.
Yes.
Very happy to have you here today, too.
Yes. Thank you so much, Madam Chair, members of the committee. I'm very pleased to be here with my good friend and principal co-author of this measure, Mr. Benoit. We've each been working on the question how to respond to a California Supreme Court opinion issued in December, which threw into question whether a Good Samaritan trying to assist somebody in a non-medical emergency is entitled to any form of immunity protection from lawsuit. I will say that, and what the bill does, by the way, very simply, is to say that a Good Samaritan acting in a medical emergency or a non-medical emergency and providing assistance is immunized from liability to the extent they don't engage in reckless or grossly negligent conduct, which boils down to being indifferent to the lives of people involved in the situation. That approach has garnered very broad support from the Civil Justice Association to the consumer attorneys and many folks in between, and no opposition. It had a 75-0 vote on the Assembly floor. And I will conclude by saying this. You know, I think all of us have been involved in situations where we were called upon to play some kind of a role. I was involved in such a situation in Los Angeles not long ago, a couple years ago, where someone on the freeway had their truck overturned right in front of me. It was a pretty desperate moment, and we don't want anybody in that kind of situation to be wondering whether they might be sued if they engage in responsible conduct to provide assistance. This bill addresses that problem, and again, I'm delighted that Mr. Benoit is my principal co-author on this measure and has worked independently on this issue as well. Mr. Benoit.
Thank you, Madam Chair, members. I'm here as a principal co-author of the Good Samaritan Bill, AB 83. Both of us, Assemblyman Fure and I, became aware of the liability protections being under potential threat after the Van Horn ruling, and each introduced separate bills to address the problem. As a former CHP officer, I can tell you there are many situations where Good Samaritans arrive first at the scene of incidents, making the difference between life and death for accident victims. It would be tragic if anyone were to hesitate to assist someone in an emergency out of fear that they might be sued. A distinguished friend of mine, Dr. Max Wheel of the Wheel Institute of Critical Medical Care in Rancho Mirage, who couldn't be here today to testify, called me immediately after reading about this decision. His institute trains hundreds of people a year in CPR, and part of the training had to do with the Good Samaritan law. He thought this called it into question. He was right. He said the Good Samaritan measure serves to assist that the socially responsible lay rescuer who serves as a brother's keeper allows them to intervene to save the life of a drowning toddler or road injury brothers and sisters in need. I couldn't agree with Dr. Wheel more. I think this is a very important step that we need to take to address the court's concerns, which I think their ruling asked us to do, and make sure that Californians have the peace of mind of knowing if they act responsibly in response to an incident, they will not be sued. With that, I would ask for your aye vote.
Thank you very much, Senator Benoit. And we do have Dr. Wheel's letter for the record as well. Thank you. We received that. All right. Any witnesses in support? Two main witnesses in support, please. 2 minutes each.
Good afternoon. Kim Stone with the Civil Justice Association of California. I'd like to start by saluting the authors for introducing this important legislation. As they so eloquently described, the Supreme Court interpreted our Health and Safety Code, which had previously been believed to provide immunity protection to all Good Samaritans, to provide immunity only to medical professionals providing medical help. That awkward result has been criticized by many because it could lead to a situation where there's a drowning victim and one person goes in to save the drowning victim and another person provides CPR, and the person who went to rescue the drowning victim could be sued for that, and the person who provides CPR wouldn't. And what happened in the Van Horn versus Torty case is there were two people driving home. They were friends, at least before, and the first car ran into a pole. The second car stopped to see what was going on. She believed she saw smoke, and in an effort to save her friend from the subsequent explosion, pulled her out of the car and allegedly caused a subsequent paralysis. And in their decision, the Supreme Court perhaps quelled future Good Samaritans from behaving in the way that we would want them to. Justice Marvin Baxter, in his concurring and dissenting opinion, pointed out that the purpose of Good Samaritan laws, of course, is to encourage persons not to pass by those in need of emergency help, but to show compassion and render the necessary aid. There's no reason why one kind of lay volunteer should be immune while another is not. And the two authors of this bill have responded to the call of Justice Baxter by introducing this legislation, and I hope you will, too, by supporting it.
Thank you very much. Next witness.
Lieutenant Wayne Billowit on behalf of the Los Angeles County Sheriff's Department, and also for the moment the Los Angeles County District Attorney Steve Cooley. We are very strong supporters of this bill, as we know from our experiences that Good Samaritans are often the first responders to many instances of crisis. So we strongly urge your support. Thank you.
Thank you very much. Other witnesses? Just want to add your name and support for the record.
Michael Corbett, representing the CSEC Excess Insurance Authority, in support of the bill, and also today speaking on behalf of the National Ski Patrol Far West Division, which is strongly in support of this measure.
Thank you very much.
Good afternoon. I'm Nancy Peverini on behalf of the Consumer Attorneys of California. We're also in support of AB 83. Thank you.
Thank you.
Madam Chairman and members, Barry Broker on behalf of the American Red Cross, also in strong support of the measure. Thank you.
Thank you very much.
Madam Chair and members, Jeff Fuller of the Association of California Insurance Companies, also in support.
Thank you. Oops. Other witnesses want to come and fill in these seats?
Jamie Morgan on behalf of the American Heart Association in strong support.
Thank you.
Jennifer Whiting with the League of California Cities in strong support.
Thank you.
Kathy Van Osten representing City of Beverly Hills in strong support.
Thank you very much.
And Hugh Bauer on behalf of the cities of Murrieta and Newport Beach, also in support.
Thank you.
Good afternoon. Afrak Vargas. I'm with the California State Firefighters Association. We're strong support.
Thank you very much. Any other witnesses in support? I don't believe there's any opposition to this measure. Anybody here to speak in opposition? And yes, Senator Harman, just one moment. I did want to point out, though, there's one technical clarifying amendment that you'll be taking as an
Of course, yes.
amendment.
Thank you very much, Madam Chair.
Okay, very good. And that's in the analysis on page 5. Senator Harman.
I'm very supportive of the bill and will be voting for it, but I did have, I don't know, just sort of abstract questions. The term non-medical care, it provides if someone renders emergency medical or non-medical care. I'm wondering, is that defined, or is it just case by case you'd look at to decide? Let's get away from the situation involving personal injuries and medical care, but what about protecting someone's property at an emergency scene, and someone does the wrong thing, I guess, that's not gross negligence? Would that be covered if the conduct of that person resulted in the building burning down or whatever? Is that covered by this bill, or is it the intent of the author that this only covers situations involving great bodily injury?
The motivation for the bill is to try to protect people.
I understand that.
And so I hadn't contemplated the situation in which only property was at stake. I think that is beyond certainly the intent of the bill. The definitional difference between medical and non-medical of the bill is this. It's meant to say that while courts have, the Supreme Court restricted the Good Samaritan immunity to medical intervention, the use of non-medical is designed to say, and every other form of intervention involving a human being who might be in some jeopardy.
Presents an interesting question. I don't know whether it's overreaching. You know, you might even think of a situation where there's a computer that's crashed, all right, and it's an emergency. Is that the scene of an emergency?
Well, that's an interesting question. I think maybe the next Attorney
somebody
General
comes
wants to
in and
grapple with
tries
that,
to
Mr.
fix your
Harman.
computer and they burn it out. Would that be covered under this bill? I don't know.
Mr. Harman, I think that there's a potential argument could be made that it would cover because the bill specifically in the language says emergency care at the scene of an emergency. That could be saving the cat at the house and it's on fire, or saving the files or the pictures off the wall. I suppose it will be litigated at some point, but I think it could be easily interpreted to mean more than just saving another person.
Yes.
It says emergency care.
Okay, all right.
Thank you.
Interesting issue.
Would you like to make the motion?
I'll move the bill.
All right, moved by Senator Harbin. Senator Benoit.
I'd just like to take 1 second to thank the chair for her efforts to make this work. As you know, this is a complicated issue. We have 2 bills. You've been very gracious in trying to make sure that it works. Thank you.
Thank you very much. It's great to see everybody working together. It's wonderful. Thank you. All right, we have a motion. Please call the roll.
Madam Chair, if I might, if there's anyone who wishes to be a co-author in the committee, that, of course, would be a welcome further amendment. People wish to.
Okay.
And I also want to thank not only the chair, but also Mr. Benoit. The teamwork has been terrific, and all the stakeholders who came together. Thank you.
Thank you very much. All right.
Thank you, sir.
Please go ahead and call the roll.
The motion is due pass as amended to the Senate floor. Corbett?
Aye.
Corbett, aye. Harmon?
Aye.
Harmon, aye. Flores? Flores, aye. Leno? Walters?
3 ayes. That will remain on call, but it has sufficient votes for passage. Thank you very much. And Assemblymember Fior, you have a committee bill. That's item 14, AB 940. So whenever you're ready.
Thank you very much, Madam Chair. This also is a very straightforward bill, no opposition, unanimous support so far. Simply would seek to codify a Supreme Court rule that has long allowed financial institutions other than banks to hold accounts for what's called interest on lawyers' trust accounts. Everyone here knows that that's a very important ingredient in how we fund our free legal services programs. I urge an aye vote.
All right. Thank you very much, Assemblymember Fior. As you noted, it doesn't appear that there's anyone in opposition, or do you have any witnesses in support?
Anthony Williams with the State Bar. We are the sponsor of the bill. Be happy to answer any questions you may have.
Thank you very much, Anthony. All right. Any questions, members?
Move the bill.
Moved by Senator Harmon. Would you like to close?
Urge an aye vote.
All right. Very good. Please call the roll.
The motion is due pass to the Senate floor. Corbett?
Aye.
Corbett, aye. Harmon?
Aye.
Harmon, aye. Flores? Flores, aye. Leno? Walters?
All right. 3 ayes, no noes. It will remain on call, but it has sufficient votes for passage.
Thank you, Madam Chair, for your continued courtesy.
Congratulations, Mr. Chair.
Thank you all very much.
All right. Our next author is Assemblymember Caballero. Please come forward. Assemblymember Caballero is here on item number 20, AJR number 2, a resolution in support of braceros.
Thank you, Madam Chair and members. The Bracero program was a labor importation program initiated by the United States government with the Mexican government in 1942 to alleviate this country's labor shortage during World War II. Over the program's 22-year life, more than 4.5 million Mexican nationals known as braceros were legally contracted to work, mostly in agriculture and in the railroad industry. Between 1942 and 1946, 10% of the wages that those workers earned was sent back to Mexico on the theory that when the program ended, they would go back to Mexico and then they would be able to collect their wages. However, upon returning to Mexico, they found that those wages that had been collected were not available to them. So in 2001, 6 former braceros filed a federal lawsuit in Mexico claiming the return of that money, and the Mexican government settled for a sum of 38,000 pesos, which roughly translates into about $3,000 in U.S. dollars. But they set up a system where they had to show original proof that they participated in the program, documents that were over 60 years old. And they had a very short window of time in which to show that proof. We had testimony from a former bracero, Mr. Gutierrez, that showed up at the hearing in the Assembly and indicated that during the course of the 60 years, he participated in the bracero program, had his wages deducted. He then became a legal resident and a U.S. citizen and worked for the same farming operation for over 60 years. When he retired, he was working for the grandchildren of the people that originally hired him to be a bracero. He produced evidence from his employment that he had worked at that ranch as a bracero and that he had been in this country for 60 years. And that information was forwarded forwarded to the court, but was not the original documentation that was presented. So here's a gentleman who who did work in this country for 60 years in agriculture, yet had no opportunity to retrieve money that was rightfully collected and sent to Mexico, for which he should have been able to petition the court to get money from. And so this resolution requests our government to request of the Mexican government that they extend the deadline in order to accept more documentation, number one, and number two, that they consider changing the requirements in regards to the original documents and provide flexibility for those individuals that can prove that they were in the program but may not have the original documents.
Well, thank you very much. Very, very important measure.
Thank you.
You have witnesses in support?
I do.
Madam Chair and members, Caitlin Vega for the California Labor Federation, here in strong support of this measure. The braceros who came over to work in the agricultural fields of California were subjected to very harsh conditions. There was little health or safety protections for them. They earned very little, but they were promised that at some point they would be paid what they were owed. And because California benefited so much from their labor, it seems appropriate that we play a role in ensuring that they do see justice after these long, many years. So we are here in strong support. Thank you.
Thank you very much. Any other witnesses in support? I don't believe there's any opposition. Any opposition? Members, questions or a motion? Moved by Senator Flores. Assemblymember Caballero, do you have a closing?
Respectfully ask for your aye vote.
Thank you very much, and thank you for bringing this very, very important measure to us today. All right, please call the roll.
The motion is be adopted and passed to the Senate floor. Corbett?
Aye.
Corbett, aye. Harmon? Harmon, aye. Flores? Flores, aye. Leno? Walters?
All right. That bill has 3 ayes, no noes. It will remain on call, but it has sufficient votes for passage.
Thank you very much.
Thank you. All right, our next author is... Oh. This is not right. Okay. Next author is Assemblymember Lowenthal. Please come forward. Assemblymember Lowenthal is here on item number 10. Sorry. I can get my binder to cooperate here. Assembly Bill 459, dealing with disclosures and dissolutions. Welcome.
Thank you. Thank you, Madam Chair and committee members. First of all, I'm happy to accept the clarifying amendments that were suggested by this committee as noted in the analysis.
Thank you very much.
This bill was on consent through the Assembly and received no votes, so I will be brief. The problem this bill seeks to resolve occurs when one party in a dissolution or legal separation does not serve the other party with the required disclosure of assets and liabilities, which holds proceedings in limbo. This is too often used as a tactic to game the system and unnecessarily block the court from granting a final judgment. AB 459 would give the court a tool to adequately deal with this problem by allowing the complying party to voluntarily waive receipt of the disclosure, provided the court determines there is good cause. This bill is sponsored by the Family Law Section of the State Bar Association. I have Michelle Brown with me today, Affirmative Legislation Chair of the State Bar's Family Law Section, to make a few remarks and answer questions.
Thank you very much. Welcome to your witness.
Thank you, Madam Chair, member of the committee, for giving me time to talk on AB 459. AB 459 will promote efficiency in the family law courts. It will allow litigants to obtain judgments without having to jump through hoops when one party refuses to participate, and will also decrease some of the gamemanship. Currently, if both parties have appeared in the action, both parties are required to serve disclosure documents, which is a list of assets, liabilities, income, and expenses. If one person fails to serve the required disclosure documents, the court currently cannot obtain a judgment of dissolution, legal separation, or terminate domestic partnership. Although the disclosures statutes are an integral part of family law, and they're very important. The problem occurs when one party chooses not to participate. This only occurs when you have both parties participating in the action. What can often happen, particularly with pro per litigants, is you file a petition and a response, and one party just disappears from the action. Right. They decide not to participate, and they don't understand that their failure to participate can stop them from terminating the marital status. It also sometimes can occur in domestic violence situations, where one party may want to prohibit the other side from terminating the status. What this bill does is it gives the courts an ability to terminate the status and enter a judgment where one party does not participate in the action. Right now, courts are having to engage in various creative ways to try to terminate the status and obtain the judgment, and this gives them the right to do that. I also think the proposed amendments that are suggested by the committee are appropriate. They ensure that there is no gamemanship by the person who's seeking to terminate the status, and FlexCom actually appreciates the amendments. And I'm here to answer any questions if anyone has any questions on AB 459, and we thank you for your consideration.
Thank you very much. That sums it up very concisely. Thank you very much. Any witnesses in opposition? All right, members, any questions? All right. We have a moved by Senator Harmon, and would you like to close, Assembly Member Lowenthal?
Thank you very much. This is a good bill. It promotes fairness and efficiency in the court system, and I respectfully ask for your aye vote.
Thank you very much. Please call the roll on the motion.
The motion is due pass as amended to the Senate floor. Corbett?
Aye.
Corbett, aye. Harmon? Aye. Harmon, aye. Flores? Flores, aye. Leno? Walters?
All right, that bill has 3 ayes, which is sufficient to pass. We will have it remain on call for other members. Thank you all very much. All right, our next author is Assemblymember Hagman. Please come forward. Good afternoon. Good afternoon. And you're here to present item number 11, AB 515, dealing with collateral recovery and tow vehicles.
Yes. Thank you, Madam Chairman and Senators. Good afternoon. I am pleased to present Assembly Bill 515, which I believe all the members have seen and voted on in the past, so I'll make it quick.
Yes, it is a little familiar.
Several small changes to current law related to licensed repossessors in terms of licensing liability, safety requirements, and punishment for unlicensed activity. Many of these are clarifying in nature. And I could go through them if you like, but joining me today is Carl Brackenstick, legislative advocate for the California Associated of Licensed Repossessors and the sponsor of AB 515.
Okay, very good. Let's hear from your witnesses, but I just want to thank you for working with staff. There are a few technical amendments. They are mentioned at comment 7 on page 7 of the analysis, and thank you for agreeing to take them on the floor,
Absolutely.
Which will allow us to save a little bit of money and avoid a reprinting of the bill. So appreciate you for working with our staff on that to save our taxpayers money. And your witnesses?
Carl Brackensick on behalf of CalR, the sponsors of the bill, and joining me is Joey Collins, our legislative coordinator.
Welcome.
Thank you. We'll answer any questions you may have.
Okay, very good. Any questions, members? I think we do know this bill. We're very familiar with it. We've learned a lot about towing in the reading of the analysis of this bill. And I think this will definitely go a long way to make the situation much more efficient. So thank you for bringing this to us. Is there a motion by Senator Harmon? Would you like to close?
I just respectfully ask for your aye vote. Thank
okay,
you.
Very good. Please call the roll.
The motion is due pass to Senate Appropriations Committee. Corbett?
Aye.
Corbett, aye. Harmon? Aye. Harmon, aye. Flores? Flores, aye. Leno? Walters?
All right. That bill has 3 ayes. That's sufficient to pass. It will remain on call for the other members.
Thank you very much.
Thank you all very much.
Thank you.
All right. Our next author is Assemblymember Monning. Please come forward. I believe you have 2 items. We'll start with item number 9, dealing with liens. It's AB 457. Good afternoon.
Good afternoon, Madam Chair, members. Thank you for this opportunity to present to you Assembly Bill 457, legislation pertaining to mechanics liens, and specifically the requirement to notify a property owner when a mechanics lien is recorded. Currently, mechanics lien filing procedures do not include a requirement that property owners be notified when a lien is placed against their property by a contractor, subcontractor, or supplier. Furthermore, many liens are not pursued and become void and unenforceable over time, though the lien remains against the property, clouding the title. Consequently, unaware property owners are left with the responsibility of addressing the lien before engaging in any financial transactions involving the property, often disrupting transactions already in escrow. AB 457 will do two things. It will require notification be given to the property owner as a condition of filing a mechanics lien, and it will require a notice of a pending lawsuit to be filed whenever a suit is filed to perfect a lien. This bill is a good bill for both sides. Not only does it provide a mechanism for notifying the property owner about a possible lien against their property, but it is also a vehicle that encourages a resolution for the subcontractors and suppliers, resulting in payment for services or supplies rendered. I'd now like to present as a witness Mr. Michael Brown from the Contractors State License Board. With your permission, Madam Chair.
Yes, thank you very much, and welcome to your witnesses. We'll have 2 main witnesses at 2 minutes each, and welcome to the committee. Nice to see you again.
Thank you, Senator. Michael Brown, representing Contractor State License Board. I think Assemblymember Monty has done a good job giving you a synopsis of this bill. The board's been looking for a way for quite some time to provide some legislation that would relieve the issues related to mechanics liens. With the help of industry, Assemblymember Monning, and this committee, I think we've drafted a good resolution for this issue for all parties involved. So we respectfully request your aye vote.
Thank you very much. Other witnesses in support?
Madam Chair, Todd Bloomstein on behalf of the Southern California Contractors Association. You may recall this issue was before you 2 years ago.
Yes.
In 2007, SB 372. We had opposed that bill based on the fact that it disciplined contractors rather than taking care of the problem, which was the stale liens that remain on title. Well, we went back to square one, put together a meeting with industry, as Mr. Brown indicated, and came up with this product, which is a much better product than SB 372, and we support this bill.
Very good. Thanks for working on it and coming back. Other witnesses in support, if you can just identify yourselves and your association for the record.
Right. Thank you. Skip Daum on behalf of the American Subcontractors Association and its attorney who materially helped write the bill. Thank you.
Thank you very much. Other witnesses?
Madam Chair, Phil Vermeulen representing the engineering contractors and various other contractor associations. Strong support. Urge your aye vote. Thank you.
Madam Chair, Kim Lewis with the Plumbing, Heating, and Cooling Contractors in support of this bill.
Thank you.
John Caldwell on behalf of the California Land Title Association. We're also in support of the bill.
Thank you very much. Any other witnesses in support? Any opposition? Any questions by members?
Just kind of a process question. How does one go about finding out who the owner of the property is? They have to give them notice by certified mail. And let's say they're a painting subcontractor or somebody like they're not dealing with the owner. They have no idea who the owner is.
It's a good question.
They have to do a property check
yeah,
through
Mr. Brown may have some response to that as well, but basically this is going to go to work performed at a particular property where the contractor subcontractor will know the address, and from that address record could secure from the county recorder's office the name of the property owner. But perhaps Mr. Brown has something to add to that?
More than likely, by the time it gets to the lien process, they're already going to know who that owner is, because a preliminary notice requires that information as well. There is a preliminary notice that must be filed. They're going to have to secure that information prior to this point, and it can be done either through obtaining that information from the county records, as the Assembly member indicates, or from the general contractor, or from the lender, if there is a lender.
Okay, thank you.
Any additional questions? Motion's in order. Oh, I'm sorry. Before we take that motion, there is an amendment that was requested on page 4 and 5 of the analysis at comment 3. Should we take those as author's amendments?
Yes, I do request an aye vote as amended. Thank you.
Very good. Would you like to close?
Yes, just request your aye vote. Thank you for the opportunity.
Thank you very much. And motion as amended by Senator Flores. Please call the roll.
The motion is due pass as amended to the Senate Appropriations Committee. Corbett?
Aye.
Corbett, aye. Harmon?
Aye.
Harmon, aye. Flores? Flores, aye. Leno? Walters?
Very good. You have 3 aye votes, no noes, and that item will remain on call, but you have sufficient votes for passage.
Thank you.
Thank you very much. And you have another item. Item number 17, Assembly Bill 1090, dealing with arbitration.
Yes, thank you, Madam Chair. Members, once again, I'm presenting Assembly Bill 1090, which protects consumers and businesses who use arbitration by making California's ethical standards non-negotiable. The increased use of mandatory arbitration clauses compelled the California State Legislature to require arbitrators in California to conform to strict ethical standards of practice when conducting arbitrations. The purpose was to hold arbitrators to a higher standard of conduct than previously required in the hopes that arbitrations will be conducted more fairly by disclosing any apparent conflict of interest. These ethical standards, however, were silent as to whether they could be waived by contractual agreement between the parties and the arbitration provider. There is some evidence to suggest that this is already occurring, but despite whether or not arbitration providers have engaged in this conduct, the loophole should be closed to protect future arbitration parties and consumers. AB 1090 thereby will clarify the intent of the legislature and ensures that arbitrations will be conducted in a fair, consumer-friendly manner by prohibiting arbitrators from contracting out of their ethical standards. The bill received unanimous support in Assembly Judiciary and no votes on the Assembly floor. I'd like to present as a witness in support Ms. Donna Brownsey, with your permission, Chair.
Thank you very much. Ms. Brownsey, welcome.
Thank you, Madam Chair. Members, Donna Brownsey here for the California Dispute Resolution Council in support of the bill. When the appellate court ruled in Azteca, they made it very clear that private contractual agreements could not waive the ethical standards for arbitrators. This bill codifies that. The CDRC supports that and believes that that this is the practice, but this law clarifies, so in case anybody has any questions, they will know that that is not an option. So we would urge your support.
Thank you very much.
Thank you. Nancy Peverini on behalf of the Consumer Attorneys of California in support. We were sponsors of the original legislation in 2001 with Senator Escutia, and certainly we always intended that those provisions could not be contractually waived, so this is consistent with what we believe was the original intent of that legislation. Thank you.
Thank you very much. Members, any questions? I don't believe there's any opposition to this measure either. Assemblymember Monning, thank you very much for bringing this legislation to ensure that we continue to have the high standards for arbitration. It's very important. Thank you. Anybody like to make a motion? Moved by Senator Flores. And would you like to close?
Yes, Madam Chair, just request and I vote. Thank you.
Okay, very good. Please call the roll.
The motion is due pass to the Senate floor. Corbett?
Aye.
Corbett, aye. Harmon? Aye. Harmon, aye. Flores? Flores, aye. Leno? Walters?
Okay, you have 3 ayes, and that's enough for passage, but it will remain on call for the other 2 senators.
Thank you, Madam Chair. Thank you, members.
Thank you very much. Congratulations. All right, our next author is Assemblymember Tran. Please come forward. The esteemed Vice Chair of the Assembly Judiciary Committee. Here on item number 7, AB 285.
Thank you, Madam Chair. Good afternoon, members. AB 285 would help simplify existing law that is both ambiguous and burdensome. AB 285 relieves corporations of the obligation to consult and follow the federal electronic signatures in Global and National Commerce Act, or otherwise known as the e-Sign Act, and instead provides a workable alternative while still using the e-Sign Act as a general guide. In other words, this measure will help business comply with federal and state laws while also using cost-effective and timely measures to communicate with their members and shareholders. In our current economic crisis, we must find effective ways to make California a better place to do business. AB 285 is one small way to achieve that goal. I have taken amendments that are strictly clarifying in nature. Would like to respectfully urge your aye vote, and I have a witness.
Thank you very much, Assemblymember Tran, and welcome to your witness.
Thank you. Jennifer Wada, here today on behalf of the Nonprofits Committee of the State Bar. This bill truly will clarify corporate electronic communications, and so we would urge your aye vote. Thank you.
Thank you very much. I don't believe there's any opposition. Is anyone here to speak in opposition?
Move the bill.
All right, moved by Senator Harmon. Would you like to close, Assemblymember Tran?
Ask for your aye vote. Thank you.
Okay, we can do that. Please call the roll.
The motion is due pass to the Senate floor. Corbett?
Aye.
Corbett, aye. Harmon?
Aye.
Harmon, aye. Flores? Flores, aye. Leno? Walters?
Okay, very good. That bill has 3 ayes, no noes. It will remain on call. And your other 2 items on consent have
Thank you,
3
Madam Chair,
ayes as well.
members. Good afternoon.
Thank you very much. All right, we have one last measure by Assemblymember Arambula. And there he is. Item number 8, Assembly Bill 442, dealing with notaries and matricula consular.
Good afternoon, Madam
This is
Chair.
a bill that's familiar to us as well. Please, go ahead.
Good afternoon, Madam Chair and members. It's my pleasure to present on Assembly Bill 442. Lack of identification can sometimes prevent individuals from having important documents notarized. Documents such as a general or living will, a power of attorney, which is especially important when minor children leave the country. They must have the appropriate documentation notarized. This Assembly bill would add the consular identification card, the matricula consular as it's known, to the list of forms of identification that may be used by a notary public to identify an individual. The consular identification card is a secure form of identification. It has a centralized database that maintains digitalized fingerprints and signatures. Beginning in the year 2002, the Mexican government enhanced the security provisions of the consular ID card, as well as tightened up the approval process for obtaining such identification. And by 2007, all previous consular ID cards had been replaced with the new high-security matricula consular, which contains security features. It also contains advanced technology, embedded images, all to prevent its forgery, much like the technology that is used for badges for the FBI. The notaries public will be trained and tested to properly accept the consular identification card via the mandatory course that they are required to take under current law. Also, the Mexican consulate provides security decoders to banks and law enforcement already, and has offered to also provide them to notaries public for this purpose. In some, Madam Chair and members, it's important for people to identify themselves for notarization purposes. Documents that are authorized, that are notarized, add authenticity and help to protect families from fraud. And on their behalf, I would respectfully ask for an aye vote.
Thank you very much, Assemblymember Arambula. I know you have witnesses here in support. Welcome to your witnesses. 2 main witnesses, 2 minutes each, please.
Good afternoon, Madam Chair and members of the committee. My name is Santiago Avila Gomez, and I'm here on behalf of the California Rural Legal Assistance Foundation and in strong support of AB 442. This important bill is needed for many of the reasons identified in the committee analysis, which, by the way, does a very good job of responding to the criticisms to the bill. I think in my work it's very much needed in that my work as a staff attorney is limited in scope to brief consultations. More often than not, that means contacting an opposing party, a governmental agency, or other creditor, for example, on behalf of a party. And oftentimes I do need to have their written authorization, and I do ask that it be notarized. Many of our clients, many of our constituents come with a matricula consular to the office, and this bill would relieve them of the burden of having to go and get one of the other documents that clearly establishes their identity. For those reasons, I urge your aye vote. Thank you.
Thank you very much. Other witnesses in support?
Madam Chair and members, Vanessa Kahina on behalf of the California Immigrant Policy Center for the reasons indicated by the other supporters and the Assemblyman, here in strong support.
Thank you very much.
Good afternoon, Madam Chair and committee members. Ginger Silvera with the California Catholic Conference, and we strongly support this bill. Thank you.
Thank you very much. Any other witnesses in support? Witnesses in opposition, please come forward. Please come forward. There's just some seats up here.
Madam Chair and members, Mike Belote for the California Escrow Association. We understand that this is a hugely sensitive issue involving cultural issues, and so this is a position that we don't take lightly. We have talked about. Okay.
We were just noting that we didn't have a letter from opposition.
We sent it last Wednesday, and I apologize if it wasn't received.
We only received opposition from the National Notary Association.
Okay. I'm sorry. We sent a joint letter with the title industry last week, and also to the author.
Okay.
So the question is not the reliability of the instrument. We understand that there is debate about that, and Mr. Arambula may well be right about that it is a more reliable instrument than it was prior. But we work very, very hard on real estate fraud issues, and real estate fraud is a big problem in California and has been for quite some time, and has gotten worse in the subprime crisis. So the question is it necessary to expand the list when the only form of identification is this consular document? There are alternatives under the current notary law involving credible witnesses, where if you know somebody who has ID under the present list and produce that person and have them appear before the notary, that will suffice. We are not aware in the real estate context that the lack of identification under present law has been a problem. Notary publics that are escrow officers tell me they don't know of cases where people have not had appropriate ID, and therefore it has prevented them from engaging in real estate transactions. So there is an option. Law enforcement tells us, although I will concede that I don't see them here today, but they have told us that they do have concerns about the fraud risk. So because there are options, we suggested that the bill be amended to exempt real estate transactions because the fraud risk is so great, and that's our position.
Thank you very much. Next witness in opposition, 2 minutes, please.
Yes, Honorable Chair and members of the committee, my name is Tim Reiniger. I'm Executive Director of the National Notary Association. And I want to start off by thanking Assemblymember Arambula's office and his staff for graciously setting up a meeting a couple weeks ago at the Mexican consulate with the Consul General. And they did invite me there in response to our initial letter. And our concerns are based on the concerns of the FBI and Department of Homeland Security. We do not pretend to be experts on identity cards and that large subject, but we do rely heavily on the FBI, Homeland Security. And when I met with the Consul General at the consulate, clearly it is true that the government of Mexico has made significant strides in adding greater security to these cards, and at many levels they have created a database to address the problem of multiple cards going to one individual, and they have added significant security elements to the card itself. So that is good, but however, there are two significant problems remaining, and the first is the assurance level of the card, that is the identity of the person getting the card, is that the real person? Has that been established? And second, despite all the security features, there are still problems with the forgery of the document. And we do have a statement, a recent statement from the FBI, which I'll just read. It's very brief. U.S. Department of Justice and the FBI have concluded that the consular ID card is not a reliable form of ID due to the non-existence of any means of verifying the true identity of the cardholder. In addition to being vulnerable to fraud, they are also vulnerable to forgery. There have been several generations of the card and even the newest version can be easily replicated despite its security features. The FBI believes there is a potential of foreign nationals to use the cards to create a well-documented but fictitious identity in the United States, and provides an opportunity for terrorists to move freely within the United States without triggering name-based watch lists that are disseminated to local police officers. It also allows them to board planes without revealing their true identity. Now, I will say that in visiting the Mexican...
Excuse me, sir, through the chair, could you identify the source of that letter? I mean, who is it addressed to, and who is it from? Is it an email, is it a letter,
yes,
whatever?
Yes, Senator. Denise Ballew, B-A-L-L-E-W, from the FBI National Press Office, dated March 13, 2009, addressed to my office.
All right, thank you very much.
And I do need to ask you to conclude because of your time has expired, but if you'd like to conclude.
Yes, so in conclusion, we echo the sentiments of CLTA and the Escrow Association in that there are already mechanisms to provide notarial services to these individuals through the form of credible witnesses. So we would argue that we should continue with that and give the Mexican government more time to address the weaknesses in the card that have been identified by the FBI and DHS. Thank you.
Thank you. Next witness, briefly.
Madam Chair, committee members, my name is Craig Page with the California Land Title Association. Again, not to reiterate any of the points other than the fact that we do believe that it would be nice to have a real estate exclusion from the use of the matricular card. We think that given that the real property is the largest interest that someone has, and so the home is of great value, that we'd like to see an exclusion from the use of it for real estate purposes.
Thank you very much. Assemblymember Ramgula, I'm going to give you an opportunity to respond to some of the comments made, but I would just state briefly, obviously we would be concerned about ensuring that these documents have a certain level of security, but I believe some of the comments made, you could make the same comments with regard to other forms of identification, which unfortunately, sadly, are not always as secure as they should be and can be counterfeited as well. So if you could just, I'm sure you'd like to respond to some of the comments that were made.
Sure. Thank you, Madam Chair. What I'd like to do to illustrate the reliability of these documents is to take one county somewhat at random, let's say Orange County, which is frankly not a hotbed of liberalism by any stretch of the imagination. These are the police departments that accept the matricula consular. Anaheim, Brea, Buena Park, Costa Mesa, Font Valley, Fullerton, Huntington Beach, Laguna Hills, and I'm skipping over quite a few. Los Alamitos, Newport Beach, Orange, Placencia, San Clemente, San Juan Capistrano, Santa Ana, Tustin, Westminster, Yorba Linda. These are all police departments, along with their city councils in this one county that have determined, along with Orange County Credit Union and PFF Bank in this one county, that have determined that this document is reliable and can be used for identification purposes. Individuals in the banking industry and the financial industry have confirmed that individuals can purchase a home with a matricula consular, along with a federal taxpayer identification number and adequate credit history. There are literally hundreds of communities in California that accept the card. Sheriffs throughout most, if not all, of the counties accept these cards for identification purposes. And currently, a notary public can accept an employee identification card as adequate identification, can accept an inmate identification card. What we're suggesting is that a matricula consular is far more reliable than some of the existing forms of identification that statute provides for. And we think that for purposes of the individuals that may not have access to other forms of identification, that the matricula consular as improved, and at this point, as of 2007, the older versions are no longer valid. So the new card with the enhanced security features that incorporates features currently used by the FBI is as, if not more reliable than current forms that are authorized for notary publics.
Thank you very much, Assemblymember Remula. Are there any questions or comments by committee members? Senator Leno?
Thank you, Madam Chair, and please excuse my absence for much of the meeting.
You know where you were.
And, preoccupied. I just wanted to clarify with the author, this is not to be used for boarding an airplane.
It is not. It is only for purposes that a notary would authenticate a document. It might be for having a minor child leave the country to indicate that they have the support of one or both of the parents. It could be for purposes of purchasing a home, which I would point out our governor has gone to great lengths to encourage the banking of the unbanked because of the security concerns of folks having large sums of money on their body or in their homes without being able to deposit it and have it more secure. And it would not be for purposes of obtaining benefits, nor would it be for purposes of boarding an aircraft or other prohibited activities.
I know you've written the bill very narrowly. I only asked the question because testimony would have suggested otherwise. And though not in Orange County and probably doesn't help make your point, I just wanted to add San Francisco to your list of cities.
Yes, I just chose that one particular county, but I do have the full list if members should like to find out what the situation is in their respective counties.
Thank you, Assemblymember Remula. Senator Harman.
I had a couple of questions. Let's start with the suggestion from the realtors and land title people to exempt real estate transactions. Would you be willing to take that type of an amendment? Have you discussed it with the industry representatives? What would be your reaction to that?
Yes, I have, Senator. I would not be inclined at this point to accept that proposed amendment simply for this reason. The matricula or consular identification card is adequate for purchasing a property. I don't see why it would be all of a sudden inadequate to transfer a property. There may well be instances of real estate fraud. I don't believe that they are due to or likely to be due to the use of this card. I support aggressive prosecution, investigation and prosecution of real estate fraud. I would not be inclined to accept the amendment because I don't feel that this would lead to additional fraud.
Second question deals with your opening comments saying that there have been some enhancements and improvements to the security by the government of Mexico. What do you base that on? Is this just hearsay statements, or have you interviewed experts and people that made these improvements? How do we know that those improvements have really been made by a foreign government?
I have received briefings, sir, and had discussions with law enforcement in my own county. The sheriff of Fresno County is in support of and has adopted an ordinance to that effect for Fresno County. The police chief of Fresno, who is the outgoing president of the Police Chiefs Association for the state of California, also supports the use of this card. So it's based on my personal review of the security features on the card, as well as interviews with folks that, in my estimation, know what they're talking about.
All right. And then the third and final question I have, if you bear with me, committee members, I'm kind of concerned by the statement attributed to the FBI that was read into the record here this afternoon. Apparently the FBI has some and Homeland Security Department apparently have concerns about the use of the card as you're proposing. Could you give me your thoughts and comments on those concerns?
To be frank with you, I have not seen those concerns. The only information that I had prior to today's hearing was a document that I believe was dated 2001 or 2002 by one agent that was referring to the prior document before these enhancements were made to the high security consular identification card. So I'm at somewhat of a loss to evaluate the authenticity or the basis for that statement. But I do know that the U.S. government has looked at the consular cards and has deemed them safe for financial transactions. And here in California, we do have, as part of the policy of this state, to encourage cities and counties to adopt them for identification purposes. This would be consistent with prior state action, and I'm not aware of anyone backtracking off of their support of these cards. So I really don't know what to make of that statement. I would need some time to investigate the authenticity and the basis.
And Senator Harman, I would also add to that the committee did not receive a copy of that letter either. That's the first I heard of it as well, and hopefully you can provide a copy for us. Thank you very much.
Make sure my office gets a copy too, would you?
Make sure all the committee members get copies. That would be great. All right. Any additional questions or comments? Senator Flores actually beat you to it. So we have a motion by Senator Flores. If there's not any additional questions, would you like to close, Assemblymember Arambula?
Just to urge you to support this bill. I think it is a modest way of helping folks to take care of their legal affairs that they're currently precluded from doing so.
Thank you very much, Assemblymember Arambula. Please call the roll.
The motion is due pass to the Senate floor. Corbett?
Aye.
Corbett, aye. Harman?
No.
Harman, no. Flores? Flores, aye. Leno?
Aye.
Leno, aye. Walters?
No.
Walters, no.
That bill passes on a 3-2 vote. Thank you very
Madam
much,
Chair. Thank you,
Assemblymember
members.
Arambula. And we're going to lift the calls on all the other measures. Shall we start with the consent calendar? Please call the consent calendar.
Leno?
Aye.
Leno, aye. Walters? Walters, aye.
That's out 5-0. We will lift the rest of the calls in file order. Item number 2, AB 63 by Assemblymember Mendoza.
Leno?
Aye.
Leno, aye. Walters?
No.
Walters, no. That's a 3-2.
That bill is out in a 3-2 vote. Item number 3, AB 83 by Assemblymember Feuer. That was the Good Samaritan bill.
The motion was due pass as amended to the Senate floor. Chair voting aye. Vice Chair voting aye. Leno?
Aye.
Leno, aye. Walters?
Aye.
Walters, aye.
That bill's out on a 5-0 vote. Item number 5, AB 170 by Assemblymember Mendoza, dealing with court reporters and certified transcripts.
Leno?
Aye.
Leno, aye. Walters?
Aye.
Walters, aye.
That bill's out on a 5-0 vote. That one is on consent. AB 285 by Assemblymember Tran, dealing with electronic transmissions in corporate communications.
Leno?
Aye.
Leno, aye. Walters?
Aye.
Walters, aye.
That bill's out on a 5-0 vote. Item number 8 we just did. Item number 9, AB 457 by Assemblymember Monning, dealing with liens.
The motion was due pass as amended to Senate Appropriations Committee. The Vice Chair and the Chair both voting aye. Leno? Leno, aye. Walters? Walters, aye.
That bill's out on a 5-0 vote. Item number 10, AB 459 by Assemblymember Lowenthal, dealing with disclosures and dissolutions. I believe that bill has 3 aye votes currently.
The motion is due pass as amended to the Senate floor. Chair and Vice Chair both voting aye. Leno?
Aye.
Leno, aye. Walters?
Aye.
Walters, aye.
That bill's out on a 5-0 vote. Item number 11, AB 515 by Assemblymember Hagman, dealing with tow vehicles and collateral recovery.
Leno?
Aye.
Leno, aye. Walters?
Aye.
Walters, aye.
That bill's out on a 5-0 vote. Item number 14, Assembly Bill 940 by the Assembly Committee on the Judiciary, dealing with attorneys' trust accounts. Please call the roll on that.
Leno?
Aye.
Leno, aye. Walters?
Aye.
Walters, aye.
That bill's out on a 5-0 vote. Item number 16, that was consent calendar item. Item number 17, AB 1090 by Assemblymember Monning, dealing with arbitration standards.
Leno?
Aye.
Leno, aye. Walters?
No.
Walters, no.
That bill is out on a 4 aye, 1 no vote. Item number 18 and 19 were on the consent calendar. And the final item, item number 20, AGR number 2 by Assemblymember Caballero, dealing with support for Braceros.
Leno.
Settlement.
Aye. Leno, aye. Walters. Walters, aye.
That bill's out on a 5-0 vote. Congratulations, committee members. We have completed our business for the day. Thank you all very much. And thank you for those of you on conference from coming back to join us, and thank you for your hard work. We're adjourned. So what time is it?